Thank you, counsel. Thank you both. State versus Murray and Brink.
May it please the court, my name is Chris Davenport and I represent the state of Florida. I'd like to reserve 2 minutes for rebuttal. This is an appeal from an order suppressing a blood test results after the defendants were involved in a fatal crash. The trial court originally entered an order after a full evidentiary hearing, finding that both defendants voluntarily consented to the blood draw. He later entered a second order, finding that just because it was voluntary wasn't enough under the 4th District Court of Opinions in Chu versus State. The trial court found that the troopers at the scene had to tell the defendants that the implied consent law requires submission only to a breath or urine test, and a blood test would be offered as an alternative. The reason that doesn't make sense in this case is the implied consent law wasn't invoked by the troopers. They had absolutely no probable cause to believe that the defendants were impaired in any way. If they had, they could have done an involuntary blood draw and actually made them submit blood. They didn't proceed in that manner because they had no probable cause to do so. Instead, they asked for a voluntary consent, and the trial court found that the defendants were not coerced, that this was purely voluntary. They agreed to do this. They signed a written consent form. They were never restrained in any way. They had to stay at the scene, of course, to cooperate with the accident investigation, but there were no coercive aspects to their voluntarily agreeing to the blood draw. This is a problem, apparently, in the trial court that comes up decently often, where this Chu case, because of the language in there, indicates that you can't request a blood draw without telling them that under the implied consent law, we only have a right to breath or urine. It makes no sense to apply that kind of rule in a situation where implied consent doesn't apply, though, because if they had read the implied consent law to the defendants, it probably would have rendered their consent involuntary, because there's a coercive aspect to that. It says that you're punished if you're not going to cooperate with us. Makes no sense any more than you would, require the police to read Miranda warnings in a consensual encounter and then say, but you don't have the right to an attorney now because this isn't custody. Essentially, the trial court required the troopers to say, under implied consent, here's what your rights are, but we're not proceeding under implied consent, so we'll move on. It just makes no sense to apply it in this context, and we would ask the court to reverse the trial court's order. If the court has no questions. Thank you.
Good morning, Your Honors. Mike Sawyer, DeCarlos Sawyer and Alba, here for Mr. Murray. And Mr. Brink is joined in our motion. The motion was granted by Judge Pope in Ocala, and we're here as a result of the state's timely appeal.
How do you respond to the argument that, in your brief, you argue that the trial court found that the two-part Chu test was required? First, the person has to be informed of implied consent. Second, they have to give voluntary consent. How does the implied consent, in a case where my understanding of implied consent is that a person has to be lawfully under arrest for DUI, and which obviously is based upon a reasonable basis for the officer to think that the person was driving in an impaired condition. So it's conceded by everyone here, apparently, that the officer had absolutely no reason to think that your client was impaired or under the influence, and he certainly wasn't under arrest. So how does implied consent enter into the picture here at all? Because it seems to me that a prerequisite to implied consent is that the officer has a basis to think you're driving under the influences, and then goes ahead and puts you under arrest and says, now we're going to take the breathalyzer or you're going to lose your license.
Well, Your Honor, this is the gravamen of Chu, and this is why Chu was decided. And contrary, no disrespect to the state, but contrary to what they said just a moment ago, and contrary to what admittedly it seems to imply in the judge's ruling, it's not that implied consent has to be read when a voluntary draw is requested of someone who shows no probable cause for arrest. What Chu says, and Chu was decided in 1988, and its progeny have come down, including Slaney in the third DCA, and I want to emphasize just briefly at this point that this is not designed to create any kind of watershed change in consensual encounter laws. This, as I'll say in a moment, is not really a standard consensual encounter. But to answer Your Honor's question, what Chu says is not that implied consent has to be read. It says, under the circumstances of proceeding on a voluntary blood draw rather than a draw for blood that can be required under 316.1932 or 316.1933 or a breath or urine test under 1932, to proceed on a voluntary blood draw, we see no reason to exclude that, provided the person has been fully informed that the implied consent law requires. Not that they have to be read implied consent just like they were being arrested.
My point, though, is why does he have to be informed of what the implied consent law requires unless the implied consent law is implicated? And I'm trying to understand as a threshold, is your position that the implied consent law is implicated in this case in any way?
It is.
Okay, and
implied
how?
consent is implicated, not because it's required to be read, because they haven't been arrested and they're not being asked for a breath or urine test, but the implied consent statutes were developed in order to give drivers, motorists in certain situations, greater protections than normally are provided by the 4th, 5th, and 14th Amendment of the U.S. Constitution and by the Florida Constitution, Section 1, 9, and 12. And that's what implied consent does. And a progeny of cases, including Sam Breen and this Court's ruling in McInnes, recognize that. But what Chu says isn't that you have to be read implied consent. It says you have to be informed that you have a choice of tests. That in this state, the only tests that are required under probable cause are breath and urine.
Well, wait a minute.
Those tests are still a choice.
I'm reading a paragraph from Slaney, and it says, notwithstanding the implied consent statutes, however, it is clear that a person arrested for DUI may, as stated in Chu, volunteer or otherwise freely consent to give a sample of his or her blood for chemical testing. A sample of such a person's blood may properly be withdrawn under these circumstances as well, quite apart from implied consent statutes, quite apart from the statutes.
It does, Your Honor. And, Your Honor, and Slaney, could you direct me to the place where you're looking
Yeah,
at?
it's, hold on. It's on page 427 of the...
Because Slaney is a third DCA case, and it actually was provided by the state as a supplemental in this case, decided in 1995. And
I promise you I read it as it's written.
one of the things that Slaney actually notes is that a blood test, it says on, in Slaney in paragraph 7 and 8, or in paragraph 6, it's clear a person arrested for DUI may, as stated in Chu, volunteer or freely consent to give a sample of blood, may probably be drawn under these circumstances as well, quite apart from the implied consent statutes. And it quotes Chu. And right above that, it says, similarly, in the 4th District Court of Appeal in Chu v. State, Chu has interpreted the above statutes. We think it's clear the legislature intended to provide, I'm paraphrasing, use of breath and urine tests except under the narrow circumstances of sections 316, 1932, and 1933. And those were amended in 1982.
Your client wasn't arrested for DUI at the time.
Was not arrested.
He wasn't even suspected of DUI at the time.
They could not force a test. But it says there's no reason to exclude a voluntary test provided the person's been fully informed that the implied consent law requires submission only to a breath or urine test, and the blood test is offered as an alternative.
I fully understand that, but there has to be some reason to give the implied consent warning first. If your client's not being arrested for DUI, he's not suspected of DUI at that point, the police officer says, would you give us because there's an accident involved here with some injuries, would you mind giving us a blood draw? The guy says, sure. I don't understand how that implicates Chu.
Well, Chu does not differentiate between someone who's been arrested and not, and in fact, in Chu, the person had not been arrested. In Chu and in its progeny, including McAvoy, the law enforcement was not proceeding under the implied consent statutes. They had probable cause to arrest a driver and chose not to. And this is what's been happening.
But they still read her the implied consent law in Chu.
In Chu, and that's the only reason why that motion to suppress did not stand, is because
well,
they had been informed.
Let me see if I understand. Is it your contention? Your contention is that the officer did not need to read read your client the implied consent law. Is that right? They needed to read some sort of a hybrid that says, you're not required, because we don't have probable cause to think that you're driving under the influence, you're not required to do anything. But if you'd like to give us a test, we have to offer you first a breath or urine test, and at your option, a blood test. So you're essentially saying that the Chu case sort of cuts from whole cloth that hybrid warning. Is that really where you're coming out at?
What it does, Your Honor, is it recognizes some due process for drivers.
Well, help me understand. We agreed that implied consent, if they had said, you got to give us if they had told your clients, you got to give us a blood test, or a breath or urine test, or at your option a blood test, or we're going to suspend your license, anything that he had done at that point would have been coercive, because that would have been just flat wrong.
That's correct, Your Honor.
Okay. And at the other end of the spectrum, you're saying that telling him nothing other than saying, would you mind giving us a blood test, and him agreeing to it, that was also wrong. Right?
It's not wrong. You can do it. You can
but
have a
but you're saying that standing alone, what happened in this case, which was, will you give us a blood test? Sure, I'd be happy to. That's also incorrect. Standing alone.
Standing alone.
So what you're telling me is that there's a middle ground there where they have to sort of give a hybrid warning that says, we don't have probable cause to force you to do anything, and there'll be no consequence if you don't, but we would like to test you. At your option, you can have breath, blood, or urine.
They have to tell them that breath and urine are options for them.
So that's you're sort of in that middle ground that Chu sort of comes up with this hybrid.
That's correct, and there's a good reason for it.
Why is there any more of a reason for that than, I mean, if a police officer is walking down the street and he sees you and thinks you look like a suspect in a case, and he says, would you mind giving me a blood test because we're going to test it for DNA to see if you're the midnight rapist or something? And you say, sure, why not? I mean, why is it any different because this guy's involved in a traffic accident?
Well, they're not free to leave under 316.027.
Well, but they're free to say no. I mean, that's really the operative issue. They're free to say no, no can do.
They are free to say no, but they've been given partial information. And keep in mind, Your Honors, that a blood test, and this is recognized in the cases, a blood test is a very invasive test. It's very invasive. There are statutes.
Wait a minute now. A colonoscopy is very invasive.
I understand.
I mean, you have blood tests all the time. I have blood tests all the time. I get a little sticker that says I was a brave boy. Your hyperbole is a little over the top. It's certainly more invasive than a breath test.
That's correct.
But, you know, let's not overstate the case.
Well,
tell me this. In Robertson, Florida Supreme Court after 1992, Supreme Court said it's clear that a person only needs the protection of the implied consent law if the testing provisions of that law actually are invoked by the state. If the defendant has consented to the test, or consent is implied on some basis independent of the DUI laws, then the blood test falls wholly outside the scope of the implied consent law. I'm trying to understand why that doesn't, just conclude the matter.
Well, I understand that that's confusing, but understanding that the implied consent law is designed to provide greater protections than we have under the state and federal constitutions to motorists that are particularly situated.
I agree with you if the implied consent law is on the table, but we all agree it isn't on the table in this case.
Well, if we're going to provide that kind of protection to drivers in which there's probable cause to believe they're under the influence, can we not provide at least the same due process protections to drivers who have not shown they might be breaking the law? Don't we have to tell them what tests are also available? That's what Chu is really saying is...
Well, but there's a big difference. And under implied consent, the state gets the benefit of presumptions. And they won't get a presumption instruction in this case if the blood test comes in. They don't get the benefit of the presumption instruction. And if your client had refused the test, they don't get to introduce that refusal because that's all under implied consent. So, I mean, it seems to me it's just a completely different ball game. You're trying to apply the rules of football to a baseball game. And it just seems to me it's two different ball games. Admittedly, they both involve a traffic accident and a motorist, but beyond that, I mean, you know, football and soccer both involve balls and fields, but beyond that, they're kind of dissimilar.
But what we're talking about is the rights of citizens of the state to be fully informed. And Chu says it's a two-pronged test. They have to be fully informed of the tests that are required in this state and that blood is an alternative, and it is a more invasive test. And the consensual encounter that Your Honor mentioned, someone walking down the street, that would be very invasive to stop someone and ask them for blood, for DNA. But that's a consensual encounter completely different than when a motorist is stopped or after an accident and there's been a death, they're not free to leave the scene, and they are asked about a blood test. If you look at what happened in Chu and in McAvoy, there was probable cause to proceed under the implied consent statutes. But law enforcement chose instead to just go get a consensual blood draw because they give less information. And they don't take a risk that if there's a motion to suppress based on improper implied consent, that they're going to lose the draw. All you got to do is get them to sign a consent form, and then we're free and clear. And in the depositions of Dillon and Mandel that are provided in the record, they both say it's standard operating procedure for them to get blood in all serious bodily injury or death cases. Standard operating procedure of Highway Patrol. And Webb specifically says that that is not good enough. You cannot have test results that are standard operating procedure. All Chu does. And Robertson did not wipe away Chu. Robertson only addresses when you can introduce blood draws if you haven't strictly complied with implied consent, but you have met its core policies and substantially complied. It does not affect Chu. Chu says if you want a voluntary draw, whether there's probable cause or not, you've got probable cause, you don't have to proceed under it. You can go get a voluntary draw, but you know you're not getting a free ride. How stressful could it be for Highway Patrol to at least tell people, as they're saying, we'd like to take your blood, that I have to let you know that under Florida law, there's a breath and a urine test available as well. And that's what Chu requires. And it's been followed by the 3rd, by the 17th Judicial Circuit, and we're asking that it be followed by the 5th in this case. Thank you, Your Honor.
Thank you, counsel.
May it please the court, Chu was an implied consent case. She had alcohol on her breath. She was acting incoherent. They read the implied consent law to her. In that context, it makes sense that people are fully informed before they make the decision to decline a test when there's going to be negative consequences. The standard operating procedure, the State versus Webb case that he cited, that case they ordered a blood draw as a matter of standard procedure, whether there was probable cause or not. There's a difference between requiring blood and asking for blood. And based on that difference, the trial court's order should be reversed. Thank you.
Thank you, counsel.
May I just, before you leave, let me just ask you one question. Do you agree that if we were to conclude that the blood can come in, assuming that the normal predicate for consent is arrived at, do you agree that the state does not get the benefit of the presumptions?
Right, because implied consent doesn't come in at all. So it's
Okay.
just a regular scientific test.
Thank you.